Hello, everybody. Hello, Nana Laura. It might be just us. It's gonna be a quiet night tonight. Maybe. Hi, Chitty. Welcome. So, before we get started, S. Buford, she messaged me today. She told me that she sent me something, and it arrived. It's apparently a random selection from the wish list. So, don't know what it is. Oh my gosh. Oh, it's a shirt. It's beautiful. I can't wait. Oh my gosh, I love it. Oh, blue is my color. And it says, it just says, enjoy your gift. Oh, thank you so much. Oh my gosh. I love that blue. I think that's the design that I loved so much that I put like 5 colors in the wish list. Hello, PH Jazz. Good to see you, sweetie. Hello, Catherine Gaston. Who you shin? I like red. I do. Yep. C-Rex picks red out for me. She says it looks sexy. I don't know about all that, on me at least, but I'll take her word for it. No way. Oh. I don't know. Can you call on it or do I? Who handles that? Hello, Eileen E. Carlin. If I have to, Nana Laura, I'll send you out another one. Hello, Psycho 1. Psycho 1. Oh, well, that was just because it was just me and Nana Laura at first. Hi, Cedar and Cherie. Every time I see that little puffball in your profile picture, it just makes me think of melted caramel. I don't know why. Hello, Charlie. How you doing, love? We're gonna have some fun tonight. At the end, I threw on Judge Wade Mercer's arraignment docket just for kicks and giggles. I don't know what's on it, but yay! I love that. Hey, maybe they can pick it up from the post office. Give it a little nudge along the way. Hello, Ava. How you doing, baby girl? So, remember when Ava wouldn't eat her dry food? I took her bowls out of her thing because I served, she's got 2 bowls, and one's always been food and the other was water, but then it just became an empty bowl. Apparently, like, I don't know, I must have given her eggs or something in it at one point, but like it had crusties on the side that I couldn't see without like leaning over the bowl. And yeah, because she stopped eating the blue buffalo too when it was in that dish. Cleaned it all out. Hopefully that fixes the problem, because once I dumped the food out of the bowl, then she'd eat it. She just wouldn't eat it in the bowl. So I'm thinking I threw away about 12 pounds of dog food for nothing and switched to one super much more expensive. Oh, I love you. I love you. I gotta teach her to talk. Hello, Jenny Green Honey. Oh, that train. I can hear it. I don't know if you guys can hear it, but I can hear it. Buttercup looks like melted caramel. Or she did. She was very pretty. Everybody's favorite paw pet, Ava the Win. I keep seeing Farmer's Dog, and I've really been considering it. It's a cooked dog food. It's a wet food, but it's made with like all natural and healthy ingredients. It's not canned, it's bagged. Crusty Eggs it is. That's your new nickname, Mortimer Duke. Hello, honey. I've always lived within a block or 2 of trains. Always. All my life. Not been planned, just happened. There's always a train and a river right by me. Hi, Spider-Man, honey. She's just wasting away. There's almost nothing left to her. Oh, that's the best. That's the best. Oh, hi, baby. We got a out of Bandit. She's begging for more treats. She has been tolerating Earl just slightly, like on separate sides of the room or the desk. And I actually got her and Tiny Kitten to sit on separate sides of the desk. Bandit tried to retreat, and I just kept petting her, and she tolerated it, and she didn't like it, but she survived. I know. Not spoiled a bit. Oh, black kitties are my favorite. I've always loved black kitties. They say that black cats stay at the pound the longest. Like, people don't adopt them, but man, when you see posts about house panthers, that they are a very desired cat. Tiny little house panthers. Like, I had to have Tiny Kitten Esquire when I saw her. I just had to. We will very soon. I actually just checked it. It's at 78.9%. It's moving fast though. It's it was supposed to be done. It was supposed to. Hi. Aww. Yeah, so had some fun with my clinic and my pharmacy today. The So I'm on hydrochlorothiazide, which is it's a diuretic, but it's necessary for my blood pressure. And yeah, I had put the request in for it, and it didn't end up getting filled. And I didn't happen to notice. It just, I portioned my pills out in the morning, and it didn't even dawn on me that it wasn't there. I'd gone a week without it. So if I look a little puffy, yeah. I ended up in compression socks yesterday, and I was like, what's going on? Turns out I have not had it for a week. My doctor was sending the refill to a cardiologist that I saw 2 years ago that no longer practices. So it wasn't getting filled. The pharmacy was tagging my doctor in it, but the clinic was sending it off to a cardiologist that I don't see anymore. Oh, yeah. Crow ran outside and never came back. And he was my baby. It could be allergies. Yeah. I think my alien would disagree. I'm kind of fond of it. It was operator error. Yeah. Ain't that the truth? Yeah, but without it, it leads to very, very high blood pressure problems and migraines and stuff. And I was having headaches, and I didn't know why I was having headaches. Oh, that's amazing. Your mom's a rock star. That is so awesome. I'm so proud of her. All right, guys. Now we can get into it. Now we can roll the show, Mr. Impatient. My crabby old coot. Captain Curmudgeon himself.
Kenya Jackson. All right, Miss Jackson, give me 1 minute. The villas at Turtle Cove, go ahead and get it started. What is the monthly rent?
Rent is $1,200 a month.
Okay.
We're seeking back rent for February, March, April, and prorated May, bringing a total to $3,832.20.
Yeah. All right, Miss Jackson. First of all, do you agree that your base monthly rent is $1,200? Your base rent, not with your trash and light.
It's $11.99, but I'll go with $1,200.
Okay. Do you agree that February through May has not been paid?
I do agree.
Okay. You feel like there's something else you want to tell me?
Yes.
Go ahead.
I contacted the owner back in February, and I did let him know that I was not going to be there. I've not been there. I have a new lease. I've been out of there since March 1st.
Let me see that lease. And do you have any proof? You said you contacted the owner.
He was on property, and I know it's admissible in court, but me and him actually talked because he came to my apartment, wanted me to stay because I'm such a good a tenant. And I had already told him that I had put the deposit, and he was, but that's nor here nor there. But I haven't been there in going on over 2 months.
Where are the keys at?
And that's the thing. I was gonna turn in the what do you call it? The mailbox keys. I never got keys to my apartment. And let me tell you the reason why I never got keys to my apartment. Because I originally was living downstairs in apartment 903.
Okay.
I mean, what 503?
Yeah, it
But
doesn't-
anyway, I moved upstairs. My daughter-in-law, the apartment I ended up moving in, I just ended up moving into her apartment. And they were supposed to come and give me new keys because when she moved out, she didn't have keys. And so when I moved in there, I did my own make ready, I did my own everything. And for over a year, I've been asking for keys. The only
You
thing
get in and out.
I work from home, so I'm always at home. And then if I'm not there, my son is from school. Somebody is, somebody is always
They
there.
get a lucky
Like I'm at
schedule.
home 95% of the time.
Got you. Okay.
And so
There was nothing to turn in.
it was nothing to turn in except for some mailbox keys.
Okay.
I never got keys.
Okay, give me 1 minute. Go ahead.
Yeah. I have spoken to Miss Jackson back in February, and she did inform me of what the owner told her, trying to get her to say. However, she did say that she was going to return the keys. I spoke to her over the speakerphone to a gentleman, and he still resides in the unit. So someone still lives there.
I don't know. I don't live there. And I haven't been there in 2 months.
Okay.
And I did speak to her with me, I'm sorry that I didn't communicate that I didn't have the actual keys. I only had the mailbox keys. And the reason why, and it's not admissible at court or anything, but I've been dealing with a lot. My brother is diagnosed with cancer. He's on his deathbed. And I've been, trying to work from home and do everything else. So I apologize that I didn't communicate with you that I didn't have actual keys.
Okay. So Miss Jackson, the keys actually are irrelevant right now.
Yeah.
I'm now worried about who is in this apartment.
That's-
Okay, it is your concern because that's the difference between you getting a judgment for 2 months or 4 months. So it is your concern. So
Okay,
don't sit here and say, I don't know.
It's not my concern. I didn't finish
Okay.
my sentence.
Okay, so
Okay.
do you honestly,
Mhm.
I'm talking to you in court and you're sworn in under oath. Do you know who is in that apartment? Yes or no? Is it a relative? Is it your son? Who is in that apartment? Because nobody could have just walked in there.
I do know who's in there, and
Okay.
it's not my son is with me.
Okay, who's in there?
A gentleman by the name of Asa Moore.
Okay, and what is his relationship to you?
He's nothing to me.
Okay, how did he get into that building?
Because he helped me move my stuff. And let me just be
Mhm.
100%. Before I let him stay with me. And when I moved out, he had left. I never had no keys, so I never knew that he went back.
Okay, okay. So the villa's at Turtle Cove. She's been completely honest, okay? I've made her become honest, and thank you for doing that. I really appreciate it. She did say she let him move in. Again, the issues with the keys. If she don't have any keys, she can't lock the door. So I don't know what the issues are with the keys, but I'm just putting all this into perspective. I have an actual lease that she has not been on the premises. She has noted that she doesn't know when he came back. And of course, the doors weren't locked. If you want to proceed with anything going on with him being on the premises now in that form, that's on you. You can hire an attorney, seek what your advice is.
She doesn't know when he went back, but she definitely knows it's him that's there.
But right now, are you still wanting the full rent till May?
Yes, ma'am.
Okay, so right now, Ms. Kenya, again, thank you for being honest. I have a lease here. I do know that there is somebody in your premises. Turn the phone off. You're in court, and I've made that announcement very clear. Well, thinking and doing it is two different things, so check it and make sure it's off. So at this point, I'm going to do February, March at 1,200. And then I will do half of, we got February, you got March, and then I'm gonna do half of April. If a phone goes off again, it's mine. And half of April, which is 600, because she has been honest, and again, I don't know what the issues are with the keys. There is somebody there, but you can have relief any other way. So judgment's gonna be in the amount of 3,000, not the full amount that they're asking for.
Can I ask I know that I do owe February. I know for a fact
Mhm.
that I do owe February. I'm not understanding why I would need to pay March, and April.
Okay.
When I left, everyone left left the apartment. When I left that apartment, there was no one in that apartment.
Actually, I'm sorry, this didn't start in April. I'm sorry. All right, so again, Miss Kenya,
And I told the
I-
owner that I was gone and I was leaving.
I
Matter of
understand.
fact, I even seen him the day before I moved out and told him I was leaving. Matter of fact, he was there when the moving trucks were there.
okay, and I understand nobody's debating that you moved out, but your occupant that you let in at the time
Yes, ma'am.
has now come back in. So your issue is with your occupant that's making you pay this money, not them. Okay, they didn't invite him in.
Okay,
They didn't let him know that you didn't have keys, that you were moving out. You let him in.
yes.
He may have moved out, but he came back in. But I get that you have a lease. So I'm making you pay February and March, and that's it, not April and May. Because I do have a legal lease that you are in some other place, but you let that occupant in. So you are going to take some responsibility for that. It's not going to be all on them. Okay, so that is why I'm making you pay the month of March, but I will not make you pay April and May. So your balance is at $2,400 with the judgment. Okay.
Can I ask one more question? So, because I'm gonna definitely get that paid off to you all. Once I get that paid off, because I just want to know what it looks like for me trying to get into another place.
Okay, so
With-
right now, yes, you will have the judgment because I just rendered it.
Right,
Once it's paid off, they have to do the release of judgment.
okay,
Okay, and that you take to wherever you go and say, hey, yeah, you see the judgment, but I have the release right here.
okay,
And it'll take it'll negate it off.
perfect.
Okay,
That's all I
and-
need. Yes, ma'am.
Okay, all right,
Thank
thank you
you.
guys. We got one more for you. Jesse Puente, come on up.
Hello, how you doing, man?
I'm good, Mr. Jesse. How are you doing?
Oh, not well under the circumstances, man.
All right, well, let's see if we can help this out.
Fair.
Let's see where we're going with
Very
this.
fair.
Turtle Coat, go ahead and get us started. What's going on?
Rent is a total of $1,299 monthly. We're seeking rent for March, which was $299 leftover, April full rent of $1,299, and May prorated, bringing a total of $1,849.40.
Yes, ma'am. All right, Mr. Puente, first of all, do you agree that your base monthly rent is $12.99?
No, ma'am, I do not.
Okay, why is that?
So I have my first payment to move in. It's at $650.
Okay, but I'm
so I
pretty sure
got-
that was prorated, but,
No, ma'am. So I moved in January the 16th
okay,
without being prorated.
okay,
I paid the sum of $650. On Christmas Eve of last year, I got hired a maintenance supervisor position.
at the complex.
Yes, ma'am. In
Okay,
charge of the 3 complexes that they run in San Antonio.
okay,
I was overseeing all 3 complexes.
got you.
With that, they never gave me a lease. It was not Miss Sharika herself. But
Of
that is
course,
the
she's
proof.
probably new,
That
right?
is the proof that they signed it. So pretty much the terms were that if they were using my services, that I was gonna be allowed to get 50% off of my rent, which
Okay.
equals the $650.
Okay, I know where you're
and-
coming from.
And as long as they use my services, that was the agreement.
Okay, how long did you work for them?
So they fired me February 21st, but this one here is my next month's rent. And she was hired at that point. It's actually her signature and it says paid on the bottom of the receipt with her signature, ma'am.
Paid Turtle
That's,
Cove.
so at that
Okay,
point,
so she didn't ask for February, we're talking about March.
okay, so
So March, you weren't employed, so your rent went back up to $12.99.
if I was not unemployed, yes,
Which
ma'am.
you, by your own testimony, you got fired in February.
Okay, yes,
So
ma'am.
again, March goes back up to $12.99, which is what she says, and she even took it off because she only paid $2.99 for March.
Excuse me? I paid $1,000.
Yes. And so you owe $2.99 because your rent goes back up to
Okay,
$12.99,
so this is the issue, ma'am.
okay?
Here's my application for
Okay.
Johnstone. I have an EPA certification with federally mandated, obviously. You cannot just go walk into the Home Depot and buy all the equipment that the 3 complexes need to maintain the daily operations.
Okay, what does that have to do with rent?
Okay, so here, as of March 1st, this is not my signature. I'm sorry, May 1st, they've continued to use my account as if I'm an employee. And in my head, obviously, they're using my access to EPA, which is a crime.
A really big crime.
It's a really big crime. So I've already have an open complaint with the FTC. I
Okay.
have an open complaint with OSHA, and I have an open complaint with EPA.
Okay.
I went and talked to Johnstone Company yesterday.
Mhm.
My account is right now, pretty much they're saying that they're gonna close my account because someone is fraudulently buying equipment without my consent and without my permission.
Okay.
I'm not being compensated for as an employee because under pretty much I got fired February 21st as an employee. Yet they've been able to access my EPA certification that took me 2 years and $18,000.
And a lot of time and money.
Yes, ma'am. I'm actually I'm getting my associate's degree in
Congratulations.
construction and trades management. So I could have been an asset to these people had they used me accordingly. So to my knowledge, if she's gonna say that I'm not an employee, they've been frauding me and they're doubled my rent. So I actually went and made a complaint in person in her office to Ms. Sharika about sexual advancements that were being made. Within the next 2 weeks, they doubled my rent and fired me.
Okay.
And yet, out of all of that, to make matters worse, they're still using my certifications EPA wise
Okay.
to gain everything that they need to run 3 apartment complexes.
Okay,
Okay.
and I'll get to her in a minute, but let me ask you, have you paid April and May?
So when I moved January 16th without a lease, I was paying $650 for 30 days. It
If you were
wasn't
employed.
$650 for 14 days. When I paid again for February, I paid $650 with her signature. They continued to use my EPA.
I
didn't know how
understand
to
that.
go about it.
Taking that out,
Yes,
did you pay April and May's
Yes, ma'am.
rent?
So what I should owe is for May, because my first month's January rent for me moving in on the 16th was never prorated. And the extra $1,000 that I paid, in
March?
May yes, ma'am. With the prorated account and with the extra $350, it actually adds up to $653, which should be
Okay.
and she actually told me herself, we're in court, so I know she has to tell the truth, that they did charge me too much and they were gonna prorate me. After I got fired, she no longer honored it. And when I brought it up, she said she didn't want to argue with me.
Okay.
It's the conversation.
Okay, give me 1 minute. Okay. And what is your name, ma'am?
Sharika.
Okay, Ms. Sharika, you're coming into the pot already boiling and don't know why it's boiling. So, I'm gonna touch base on this, and that's about all I can do because this is an open case and a bunch of different agencies that I cannot step foot in.
Yes.
But I'm telling you right now, if your company is using his signature fraudulently in his account, you're in a lot more trouble than an eviction court, okay? So, go ahead.
So when he left the company, he actually had his name removed. That's what Johnstone told us. So our current HVAC person submitted his application.
Okay.
So it's
Oh,
on the.
we're not doing that
Okay,
because this
but I just
isn't,
wanna
I'm
bring
not
up-
OCA and I'm not the Better Business
I
Bureau.
understand.
So you're lucky we're even talking about this because this is so far from eviction that we're done. It's the only reason we're talking is because it relates back to somehow rent.
Yes, ma'am.
So I don't need a response right now.
I
I
just
let you
wanted to-
talk. Let me finish
Yes,
with
ma'am.
her,
I
okay?
understand.
So if that's not an issue, then that's not an issue. But if it is an issue, I'm just letting you know, it's gonna be a big issue, okay? So that's all I'm gonna touch base on that. Again, he's got his open case and y'all can deal with that in
Yes, ma'am.
y'all's courts and whatever it comes through. Okay, so right now, Miss Shanice, I have an money order for March for $1,000. Do you have that credited on your ledger?
Yes, ma'am.
Okay, and where did that go?
So it brought the total down to $299.
That's for March's rent, okay.
Yes, ma'am.
Now, are you aware that rent was being split in half when he was working there?
Yes.
And then again, he let go in February, and I get where your numbers are coming from, and we're staying with that.
Yes.
Okay. So, Mr. Jesse, I have the $1,000 that you put in for March, which leaves you the $299. Okay, do we have a lease locking them in at $1,200?
Yes, we do have a lease.
Can I see that?
I don't have it with me.
So I've never received a lease, and I would have been glad if she could have provided it,
Is
because
that the lease
I've
in your
never.
hand right there?
So this is a paper that they brought to me, and originally it had another person's name. It had Jesselyn, Rodriguez or another name. So what the property manager informed me that Ms. Sharika told her to tear off the paper with another person's name on it and to hand me this. And all this states, and the only reason I brought it, because I feel it's irrelevant, is that it has the date that I moved in on 1/16.
Is your name on that paper anywhere?
Yes, ma'am.
Okay, let me see what's going on.
I said that I moved in January the 16th. Yes, sir. And I paid $650 for 30 days.
Okay.
That wasn't prorated.
Okay,
And she
give-
acknowledged, and it just never.
Okay, give me 1 minute, Jesse. Okay, let me read this, okay?
So that was given to me in March of 21st, maybe like almost a month after I got fired. They started, so all the. we
Okay,
had another-
Jesse,
Yes,
wait
ma'am.
1 minute.
Okay.
Jesse, do I have a lease where you actually signed?
No.
Okay, there's no signature here.
We have it in the office. I just don't have
Okay.
it.
So I'm gonna reset you 1 week because I need to see that lease, because
Okay.
I need to lock them into 1,200. If not, the best you're gonna get is possession only.
Oh, the $12.99?
The $12.99, that's what I
Yes,
mean.
ma'am.
Okay, unless you want to take possession only today. It's up to you.
We
If
can-
you
we
want
can move.
money, I need to see a lease locking them in.
Mhm.
If you're okay with possession, I can move forward today.
We're okay with possession, Your Honor. If they're not going to pay the rent, then we just want to get possession of the property.
Okay, so then let's revise all this, Jesse. Forget about everything we just talked about, because at this point, they just want possession, so it's not gonna be a money judgment at all. Okay, you do admit that you owe rent. I just heard you say you owe May
For the
at
month of
least,
May,
so
yes, ma'am.
that's enough to proceed forward with the possession only.
And so we're not gonna take into account that I'm being used as an employee and it's not being
Okay.
granted?
This isn't the court to fight that in. I've already told you, I'm not the Better Business Bureau.
No, I
Okay,
understand that.
I can't determine that they're using your account. She's got a reason, listen to me. She has got her reasons, and she is stating that somebody else is using that on their own account. Okay, I'm not here to make that decision. That's in another court. So we're not talking about that anymore, because I cannot even discuss that in this court. Okay.
So she's saying that they're not using my account, but all 30 of these, they use my phone number.
Then
to
you
gain
take that up with the court that is responsible for that.
Okay.
That's not an eviction court.
So, I
So,
mean,
She's
I
not
thought I,
asking for money. So even if your rent was at $6.99, let's just say it's $6.99 because that's what you keep arguing.
yes, ma'am.
Say it's $6.99. Say she dropped it down to $6.99. She's not asking for money. She's just asking for possession. You admit that you owe May. So if anything, you should have a judgment in the least for $6.99. She's not even giving you a money judgment. She doesn't even want the $6.99. She don't want the $12.99. She don't want anything. She just wants possession.
Yeah,
So,
if I was her, I'd get further away as I can as well. Just
okay,
'cause
let's
you
keep
said
your
this
comments to yourself.
This
Okay.
isn't the court.
Again, I'm not saying you don't have recourse,
This is my
and you're,
Security card, it has my birth certificate on, I mean, my ID number. I just don't understand how. Are we gonna talk about the prorated January month, ma'am? Is that gonna be taken into account that I paid full month's rent and I stayed there for 14 days and it just never, even though she said it was, that they know they overcharged me, it never got, pretty much.
okay.
It's getting thrown to the dog?
No, it's not getting thrown to the dog. She's not asking for no money. She's waiving all monies. So whether it trickled down or not, if it did, say goes into May's rent. You admit you haven't paid May's rent.
Yes, ma'am.
You're still there. So by law, you owe her, according to you, $6.99.
I have the $6.99.
She doesn't want it.
Okay,
She doesn't want it. Okay, she wants you out,
Okay.
okay? And that is her prerogative because May has not been made. She's not asking for not even the $6.99. She don't want nothing, nothing. So whether she owes you a penny or whether you owe her a penny, she's not asking for anything. She's just asking for possession. Now, again, I'm not saying you don't have recourse with the situation you're going through, but again, it's not in this court. Wait till you get your court hearing for that and you can tell the judge everything. And if they penalize them, that's on them, okay? but right now it's for possession only. So can you move out in 5 days?
No, ma'am. I would like to appeal immediately.
Okay, all right, and that's your right. You have that right.
So do I appeal with you?
Yeah, well, not here literally in the court, but you can go up to the front and appeal.
Right now, today?
You want?
No, that's what.
You would think he's making allegations of, you know, hugging misconduct, we'll call it for YouTube's sake, and that they fired him after he reported it, and then continued to use his account, which is highly illegal. You would think he would want out of that property as fast as he could get out. This should be a blessing for him.
I mean, ma'am,
You got 5 days to move out or appeal it. So you got 5 days.
So I don't know what I'm supposed to do. So obviously, after everything, I do not want to be homeless. I have my kids there. So can you advise me on exactly what to do? I walk around the corner and I.
So let's not use the word advice because I can't advise you on anything. I can let you know that my clerks are in the front and they can answer procedural questions. Okay, which means they can answer questions about the timing of the appeal. They cannot help you file the appeal. They are not attorneys, so they cannot help you. Okay, if you need the number to legal aid, my clerk, you can come up here. My clerk can give you the number to legal aid. You can call them. They're attorneys and they can help you out. But if you want to appeal today, you can go up to the front and my clerks will give you the paperwork to file the
So
appeal.
what court do I do where I've reported the sexual advances to my director and got fired for doing it?
Okay,
Is
you
that
can
not this court?
No, you can contact an attorney and it'll tell you what court you can file in. I'm not your attorney and I can't give you any legal advice. You need to contact an attorney for all the questions that you have. I will lose my job if I give you any legal advice on the bench.
And on record, they are breaking the law. They are using my account.
Okay, okay,
for the record,
Mr.
they're
Jesse,
using it as
I
an
get it.
employee.
There is no record in this court. It is a court of no record.
Stating it for the record, they're using my information and they're defrauding me.
Okay.
So,
Okay, and you can take that up with your attorney in any court that you go into. Right now, judgment is for possession only. You got 5 days to move out or appeal it. Okay,
so in the front.
in the front with
around
my
the corner,
clerks.
but not being advised, just, and not be homeless here. I know that's what y'all want.
I suggest you stop with your comments. Thank you, ma'am. You might want to take a seat for a minute.
Okay.
Let him, you can sit in the back. Let him finish his business here.
I have a feeling that his mouth may have also played a role in his termination. He's a bit of a stubborn one, it seems.
All right, ma'am, can you tell me your name, please?
Good afternoon. I'm Wendy DeVozo. I'm attorney for defendant Donald Blankenship, and I'm here with Mr. Blankenship.
Okay, thank you. I did not have Mr. Blankenship as represented. Are you making your appearance here today on his behalf?
Yes, Your Honor, I am. I was just retained, and we've actually filed a motion to set aside the default. But I don't think the court even has it yet.
Okay, let me, we've got one other party here. Let me see if this is Miss Blankenship. So just hold on for 1 second.
Certainly.
Hello,
Hello, can you tell me your name, please?
Dorothy Blankenship.
Okay, all right, so we'll go on the record in Blankenship versus Blankenship. This is file number 2514710. The record should reflect that both the parties are present by Zoom video, and counsel, again, if you can put your appearance on for the record, please.
Yes, Your Honor. Good afternoon. Wendy DeVozo appearing on behalf of the defendant husband, Donald Blankenship. And Your Honor, my P number is 54496. I'm out of Cadillac, Michigan.
Okay, thank you. This was set today for entry of a judgment of divorce by default. And Ms. DeVozo, can you just make a record of how you want to proceed today.
Yes, Your Honor. We're asking the court to actually dismiss the motion for entry of default judgment. First and foremost, the plaintiff did not serve a proposed divorce on Mr. Blankenship according to the court rule 3.210B4A. But in fact, her motion says that she did. So we have no idea what she's asking the court to accept, for starters. Secondly, I was just retained and I've filed, or on its way to the court, is a motion to set aside the default, the filing fee, and a response to today's motion, as well as my appearance. We are asking that the court set aside the default. The parties were actually working together and in fact had ironed out some terms, and Mr. Blankenship did prepare, and I'm going to use the word file in quotes, filed an answer with Ms. Blankenship, and I've got a receipt dated April 1st, 2020 to her and had shared that with her. But meanwhile, she went to the court and got a default. So I think that if the court hears the motion, there's good cause to show that the default should be set aside. Additionally, this is a long-term marriage. Mr. Blankenship is disabled and he is going to need his fair share of the marital estate. And so there are some important issues to decide here. So I know my motion's not before the court, but as far as request for a default judgment today, we're asking that that be dismissed for all of the above reasons.
All right, thank you. Ms. Blankenship, what is your position on this?
I would like to get this done. He may have mailed that on April 1st, but he did not serve me. I did not pick that up until the 14th. So well over the allotted time as far as that. And as far as, yes, most of the stuff we have agreed on, we have come to an agreement upon. The only thing that I am asking is regarding the equity of the home. We refinanced the home in 2022. At that time, Donald and myself both got half of the equity. He took the entire equity, had it placed into an account that was in his name only that I was not aware of. He had to then re-give me the half back that we agreed upon. So the equity has already been split. It was split in January of 2022 when we refinanced the home. There's also a matter of, we had ice damage in February just before filing, which Don had took it upon himself, even though he wasn't staying here, or fixed the roof, to file a claim against the homeowner's insurance, which will leave me to fix the roof because they denied the claim, will leave me to fix the entire front portion of the house, the walls and the floor in the bedroom. So as far as equity, I don't think it should be split 50-50. He is saying, I think that the equity has already been taken out of the home. And I'm left with a lot of cleanup. We cut 10 acres worth of pine due to the pine beetle, and he received half of that money as well, is that myself. And then also significant amount of garbage on the property that will take multiple dumpsters to clean up, which I sent to you and him in evidence.
Okay.
He didn't believe that my divorce papers, and he stated to me that I did not believe that I filed for divorce, and that was his reasoning to me for not responding in a timely manner.
Okay. All right. Number one, Ms. Blankenship, just so you're aware, I'm not making any decisions today about how the property should be divided up, and certainly the court will take into account your side of things, just as I will Mr. Blankenship's side of things. In terms of moving forward today, under the law, the court is required to make sure that any judgment that's entered in a divorce case is fair and equitable. So even if the default were to go forward, any judgment that was entered, the court would still be required to make that consideration. So
Correct.
in light of that, in light of the issues that both sides have raised here today, and without making a decision about whether the court will or won't set aside the default yet, the court cannot enter a judgment of divorce today, in my view. So, Ms. DeVozo, did you get a hearing date already for my office?
We're working on it. We did make an attempt to, but we haven't heard back from the court, so we'll continue to get that, to work on that and get the soonest date we can, so we can get this moving forward. I don't think anybody wants to spend a lot of needless time and money, but you know, here we are, so we'll try to move it forward quickly.
Well, Your Honor, I am stuck paying every bill because Donald has not paid one bill in this home, not a dollar towards anything in this home since February of this year. So I have been left to pay every single bill in this home. He has left all of his responsibilities onto me, leaving me with $600 electric bills and the house payment and his phone bill up until this last month, his car insurance up until the last month and everything else. So he has took every dollar of income that he has and used it for himself,
Okay.
which
Well,
has allowed him to retain the attorney, apparently.
Okay. If all of that is true, then that's certainly gonna make a difference in how things
Yeah.
are divided up. So, you know, the only thing I would say, Ms. Blankenship, is you may want to consider retaining your own counsel.
I
to
guess
make
I
sure
will
that you're
have
right.
to. That's why I was trying to move forward. We do still agree on everything. I'm not sure why he retained a lawyer other than the house. That's the only thing. He wants half of the house, and I was leaving that in your decision to make. He has also assets that he did not report. Even when he responded, his drag car that he claims is a 1963 split window vet worth considerable amount of money, not the $2,000 he claimed. He also has a 1985 square to body pickup truck that it is his friend Joe Steele's residence or his place of work at Extreme Automotive, as well as a 72 soft top Nova. He's also removed items from the property since the divorce, and he has sold items since the divorce.
Your Honor.
Well, look, this is, I'm not making any decisions today, Ms. Blankenship. I understand that's your position. As I sit here, I have no idea what has gone on so far. So all of that's gonna have to be hashed out either by agreement of the parties or through court proceedings. So again, Ms. Blankenship, it may be in your best interest to consult with an attorney here so that you can make sure that your rights are protected. As it is, we're going to proceed, Ms. DeVozo, with your motion to set aside the default. The court will make a ruling on that once we have a hearing for it. I am going to ask that you file, if you haven't already, a written appearance for the court file, in addition to your appearance on the record here today. And we'll go forward with that motion once that's set. And Ms. Blankenship, you will receive notice of the date and time of that. And that's how we'll proceed.
Yeah, that sounds good. And I've done all of it. I've filed a written appearance, or it's on its way to the court. So I'll follow up with a hearing date then.
Okay. All right. Thank you. That's all for this hearing today. And both sides are free to disconnect at this time.
Thank you. Have a good day.
For that arraignment, we're going to read you the charges. We're going to tell you what your rights are, and then we're going to address bond. Can you hear me, Mr. Hooker?
Yes, Your Honor.
All right. The complaint against you reads as follows. It says that on or about May the 4th of 2025 in Bagley Township of Otsego County, that you did commit 4 offenses. Count 1 is called police officer assault, resist, or obstruct. And it says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Brandon Walker, a sheriff or deputy sheriff of the county of Otsego, that you knew or had reason to know was performing his or her duties contrary to compiled laws. That is a felony offense. It has a maximum penalty of 2 years and or a $2,000 fine. Do you understand the charge in count 1?
Yes, Your Honor.
You understand the maximum penalty in count 1?
Yes, Your Honor.
Count 2 says that you did interfere with electronic communications and that you willfully and maliciously did prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line contrary to Michigan compiled laws. That's also a felony offense, has a maximum penalty of 2 years and or $1,000 fine. Do you understand the name of count 2?
Yes, Your Honor.
You understand the maximum penalty in count 2?
Yes, Your Honor.
Count 3 is called domestic violence. It says that you, on that same date, time, and place, that you did make an assault or an assault and battery upon Kevin Lee Hooker, a resident or former resident of your household, contrary to Michigan compiled laws. That's a misdemeanor, has a maximum penalty of 93 days and or a $500 fine. Do you understand the name of the charge in count 3?
Yes, Your Honor.
You understand the maximum penalty in count 3?
Yes, Your Honor.
All right, and in count 4, it's a similar charge. It has a name of domestic violence. It says that on that same date, time, and place that you did make an assault or an assault and battery upon Sandra Lee Hooker, a resident or former resident of your household. Again, that's a misdemeanor offense with a 93-day and or $500 fine. You understand the name of the charge in count 4?
Yes, Your Honor.
And you also understand the maximum penalty in count 4?
Yes.
All right. As to each of those 4 charges, you have the following rights. You have the right to plead guilty, not guilty, or to stand mute. And if you stand mute, I will enter a not guilty plea on your behalf. You also have the right to have a trial by a judge or by a jury, and to have the assistance of an attorney at all critical stages of the proceedings. And Mr. Brown is here as a defense attorney to assist us with that process. As a person charged with a crime, you also have the right to the following trial rights: to see, hear, and question the witnesses against you, to call witnesses on your behalf, and to get an order from the court called a subpoena to require the witnesses to appear and testify for you. You have the right to be a witness for yourself or to remain silent. And if you chose to remain silent, that silence could not be used against you. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. At a trial, you'd also have the right to appeal automatically. However, if you enter a plea at any time in the future, you could only ask the court for permission to appeal. You understand all those rights?
Yes, Your Honor.
Do you have any questions about any of them?
No, Your Honor.
All right, what we're going to do now is we're going to ask Mr. Brown to assist us with whether or not you qualify for court-appointed counsel. Mr. Brown?
Your Honor, he does qualify. If the court will remember, he was being arraigned back on April 29th, so just last week. He did qualify at that time. He will qualify again. That information has been sent to Mr. Gilo's office. My guess is Mr. Dick will be his attorney, as he represents him on the other cases as well.
All right, Mr. Hooker, are you asking for a court-appointed counsel in this case?
Yes, please.
Was that a yes?
I would like James Dick.
All right, well, at this moment, I can't necessarily guarantee that you're going to get Mr.
I know
Dick.
you cannot guarantee me James Dick. I'm sorry for speaking. I hear you. I hear you.
All right, thank you. What I'm going to do is I'm going to approve your request for court-appointed counsel. That will go to Mr. Gilo, who makes the actual assignment of each attorney that's appointed. It's highly likely that he will do Mr. Dick for you, but that's up to him. Because you're charged with a felony and you haven't had a chance to speak with your lawyer yet, I'm going to enter a standing mute or not guilty plea on your behalf in order to preserve your rights. I'm also going to set some court hearings in quick order to also preserve your rights. You have the right to have a probable cause conference. That's a short hearing between your lawyer and the prosecutor to try to see if they can resolve the case. That will happen within the next 7 days. And you also have the right to have a preliminary examination within the next 21 days. And that's a short hearing in district court in front of me to determine if there's probable cause that you committed the crimes that you're charged with. And we'll set that for a date as quickly as possible within that time frame as well. What we're going to do now is we're going to address bond. So I'm going to ask each of the lawyers to tell me what they think bond should be. And then I'm going to give you an opportunity to tell me what you think bond should be as well. So Ms. Brucker, go ahead.
Your Honor, we're asking for a very high bond in this case for a few reasons. First, as the court is aware, defendant is currently out on bond for an assault by strangulation and domestic violence charge with an unrelated victim. Last week, he was arraigned on a bond violation for that case and was released on a PR bond, and that violation is still pending. During the course of this investigation, one of the victims indicated to law enforcement that she was afraid that the defendant was going to seriously injure or kill her. He was also showing some signs that he was experiencing some type of mental health difficulties. The officer noticed that right away. And one of the other victims also reported another assault that had happened a week or so ago involving the same defendant. So I would ask that the court order the standard terms and conditions of bond, including that if he is released, that he report to community corrections. I'd ask that the court consider that he having him be evaluated by community mental health prior to his release as well. And I'm asking for $100,000, 10% bond.
All right. I know, I gotta contain myself.
Okay,
but it's not- not a lot to talk about.
Mr. Hooker. you
Mr.
need to
Hooker, I'm
wait.
gonna give you a chance to say things about this case, but you got to give everybody else a chance to talk without interfering with that. So you're gonna have your chance, sir. Now is Mr. Brown's opportunity, and then we'll come back to you, sir. All right, go ahead, Mr. Brown.
I thank you, Your Honor. As Ms. Bruker did mention, he was arraigned just last week. He is currently trying to get some employment here. I believe he has missed a couple of interviews because of his incarcerations. I would not disagree with Ms. Bruker as far as maybe a CMH evaluation. I believe there may be some mental health issues going on here. I would ask the court if the alleged victim is perhaps his grandmother. I really don't know who it is because he does live with his grandmother, and that may be, I see Ms. Bruker nodding her head. So, and again, I did not know that, but he would not be allowed to return to that home. And so I don't know if he has a place to go at this particular time. I'd ask the court to consider if he can provide any proof or anything that maybe he can get into some kind of a mental health treatment center that the court would perhaps entertain some kind of a motion. And I don't know, Mr. Dick will be appointed. It's my guess. I will be contacting Mr. Dick to inform him of this after this hearing as well. But I would just, $100,000, I understand that is a very large amount. I would consider the court perhaps imposing a lesser amount. But I will leave that up to the court's discretion.
Judge, and I forgot to say this, and it's on my bond sheet, though I am asking that the court impose protective conditions, including that he not have contact with either victim and he not return to that property. They do not want him to come back to that residence.
I charge you to go.
You understand.
My property.
All right, Mr.
I have
Hooker.
property.
Mr. Hooker, I need you to wait just a second. I want a couple things I'm going to tell you before you have a chance to tell me what it is that you want me to know. First is, I am going to listen to what you have to say. Second is, I don't want you to make statements about the case that's being charged against you, because this is all being recorded and it might be used against you later in violation of your or against your rights. That having said that, you can tell me about other things other than the case itself. You can tell me about where you live or where you're going to live, what your mental state is, whether you're employed or not, where you're going to go and what you're going to do if you get out of jail, all of those kinds of things. Do you understand, sir?
Yes.
All right, this is your opportunity. If you want to talk to me about bond, please go ahead.
All right. I believe a PR bond is well worth nothing, is the way I would like to go. I don't have any financial money put aside. I don't have a lot of money on hand and I don't have a job. I was applying, I got hired at debris cleanup documentation out at Walmart. And then I had an interview on the following Tuesday. So it was Monday and I got picked up and arrested. I missed my job training. I also missed my job interview. And that really messed me up. And I haven't been sleeping. So I would really like to get a job and do something with my day. And I've been trying to get a job. I was like, the other night I was going to post on Facebook at like 2 o'clock in the morning, 9 o'clock at night. Would anyone like any yard work done? Then I thought about it. That's a little weird to post at 9 o'clock at night. Maybe I'll wait till noon the next day and think about it. But I really would just like to have a job and go back to my own property, which is at Vanderbilt, Michigan, where my grandpa lived. And it's just a barn in the woods that I just got to build. But I don't want to build it by myself. And I don't want to either. And it's messy, it's dirty, but I got to do it. And it's going to take time, effort, and a whole lot of money and a little bit of love. And I'm glad I got time, effort, and at least a little bit of love in my heart. But yeah, I don't think there needs to be any bond number because I don't have any money. just want to make money so I can give my back to my owner.
All right.
My dad wants to wave money in my face, and I ain't got no money to give him. I ain't got no money, got no job. I can do work. I need to be able to do the work.
All right, Mr. Hooker, I see that you're very upset and you're crying a little bit there. I understand you're going through some. All right, then are you having problems controlling your emotions lately?
No, I'm not having problems controlling my emotions. I'm just having emotional outbursts, and I am apologizing for that, but I'm able to communicate and have solid conversations.
Can you tell me why you go 1 minute very, very emotional and the next minute you're almost analytical and stone-faced?
Do you want to see why I describe that? So in the moment, I'm going to get emotional, and the emotions rile me, and then my head's like, hey man, settle down. You don't need to be all emotional. And so instead of being emotional, it goes to that stone face. And then you like stone face, that's too much emotion, no emotion. We need some emotion. I'm not the best guy in the world. I don't know everything. I don't know how to communicate properly sometimes. So like if the tone of stuff I'm using is too high, you gotta calm yourself down. And so when I tell someone I'm trying to calm down, I really am.
I believe you. I'm just wondering if that's getting, I wonder if that's getting happening more often and getting more difficult for you over the last few weeks.
No, it hasn't been getting more. It hasn't happened more often, but the fact of the matter is things have been difficult in this last month.
I can understand that. I do.
I know.
All right. Is there anything else that you want to talk to me about bond about?
That I believe it should be personal reconnaissance. I can go to my own property, and I won't be in contact with anyone who I don't need to be in contact. But I'd like to talk to my grandma and dad.
All right. As to bond, I do believe that Mr. Hooker has been in front of me a number of times in the last couple of weeks. I do recall the recent assault strangulation bond hearing and arraignment. I do know that there's been a probation violation alleged in that file, and he's recently committed or is alleged to have committed in this file with the domestic violence on 2 different family members again. And that would constitute a second or third violation of probation. Under those circumstances, I don't believe that a personal recognizance bond would be appropriate. This is, however, the felonies charged in this case are not as severe as the assault strangulation case last time, so I don't know that a $100,000 bond, even at 10%, would be appropriate.
I know I'm trying, as I tell you, I'm a man, I'm trying.
I appreciate that, Mr. Hooker.
Fuck yeah, I know you do. You know, holy fuck, goddamn, give me a fucking moment.
Mr. Hooker, you need to calm down and watch your language, please.
Thank you, Deputy. Yeah,
Thank
Mr. Hooker,
you.
this is
I'm
on.
trying.
All right, the time for you talking is done at this point. This is my time. All right, we all take turns when we're on Zoom. So your chance is done. So just listen to me, please, and then we'll get through this as quickly as we can. So I'm going to do the following. We're going to institute a bond of $20,000, cash surety or 10%.
Yeah, okay, I just want to fucking sit here.
He's going to personally appear for every scheduled court date. He's going to have to abide by the judgments in this case. Cannot leave the state of Michigan without prior permission of the court, not to commit any other crime while he is released, and immediately notify the court in writing of any change of address or telephone number. He's not to use alcohol or illegal controlled substances if he's released. He must participate in a substance abuse testing or monitoring program through the Community Corrections Department. He is not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any other conduct that would place any of the following persons or children in reasonable fear of bodily injury. That would include any resident or former resident of his household, and specifically Sandra Hooker and or Kevin Hooker.
I'm fucking father.
He is not to assault, harass, intimidate, beat, molest, wound, or threaten Sandra Hooker or Kevin Hooker. He's not to have any contact,
You
direct or
plan on
indirect,
it, nor did I.
with Sandra Hooker or Kevin Hooker. Mr. Hooker, this is not your time to speak.
I understand and I apologize, Your Honor.
It's all right. Just keep it under control. He's not to enter the following premises within 50 feet of Sandra Hooker or Kevin Hooker's residence or place of employment. He is to contact community corrections at the number on the bond form immediately upon any release and prior to his release.
Walmart, because I called Walmart. I did. You guys gave me the phone number for Walmart. And I called Walmart.
He is to have a CMH evaluation prior to any release.
I hope so. I would like to talk to someone with a goddamn brain cell.
And follow all recommendations. Deputy, it's also my request that he have an immediate CMH evaluation. I believe it would be appropriate for him to have that.
Yes, thank you.
I'll make that.
Okay, I'm trying to relax. I'm not gonna hurt you. I'm not gonna hurt myself. I know, but I'm acting all hoopty-doopty and I apologize.
Mr. Hooker, thank you for your apology, but I need you to calm down and just listen to me. We're almost done with this.
I am trying to work on it. I cannot do it like that. And if I do, I will go stone-faced and you still fucking mock me. So I apologize for my language and my mannerism.
Just keep it calm. That's all we're trying to do.
I can bang my head against the wall, but I'm not. I know.
All right. That'll be the order of the court. Thank you. That's all.
Thank you, Your Honor.
Stand up.
Good luck to you, Mr. Hooker.
Right to the back wall.
I know, it's all being butt bug.
Turn around, facing. Right here, please.
Okay.
Turn your camera on. What's your name? Good morning, sir.
Kroski.
Keyshawn. Put you in the breakout room with Miss Becker so she can understand why I'm putting you in the breakout.
Okay.
Your Honor, I don't need a breakout room with Mr. Kroski.
Need a breakout room, but I don't see a shirt on. Should figure it out.
Oh yeah. Let me go put a shirt. I'm sorry about that.
Mm-hmm. Good morning, ma'am. What's your name on iPhone?
So join the breakout room now, or
No, go dress appropriately for court.
Okay, I'm sorry.
Okay. Y'all interrupting my flow. Ma'am, what's your name on the iPhone?
Elijah Welch.
All right, Ms. Welch, stay logged in. Haven't forgotten about you.
Okay, I'm sorry.
Put you in the waiting room. G501117 and 7 people state of Michigan versus Keyshawn Lamar. Prosecutor charged on 1 count of domestic violence. Appearance to the record.
Good morning, Your Honor. Laura Kamaj on behalf of the people.
Good morning, Your Honor. Hillary Becker appearing on behalf of Mr. Kroski. We do consent to these Zoom video proceedings. Sir, please state your name for the record.
Keyshawn Kroski.
Okay, we are here for a final pretrial on this matter. We have a jury trial set for next week on the 14th. I don't see Elisa Addison in my waiting room on Zoom. She's not in the court. So have we had contact with Miss Addison?
No.
Judge, for the
ahead.
record, I did send subpoenas regarding this case for next week's jury trial. I don't know. I don't have confirmation whether service was completed or not. I did call her yesterday. She did answer my phone call. She said she was unable to talk then, that she would give me a call back. She has not given me a call back yet. That is all the information that I have.
Becker?
Your Honor, I'm respectfully requesting dismissal. We had a pretrial order that was entered on February 27th. That pursuant to your orders indicated that that could be a potential remedy. This matter has been set since then for a trial. Ms. Kamaja indicated that she doesn't have proof of service. She spoke with this woman for like 2 seconds, and so I would respectfully request a dismissal. They can always rewrite the case.
All right. You know, we'll continue it to try because she did make contact. But Miss Kamaja, I need to know something by 13. You know, like she, obviously she gonna come to trial. What are we doing?
And she was required to appear today, and didn't.
And I agree with, she did make contact. I'm leaning toward dismissal, Ms. Kamaja, because obviously you called her. She know who you are. She knows why you're calling. At that point, it should have been a part of her to call you back.
Your Honor,
Yeah.
we had jury instructions due today. I did send mine over to Ms. Kamaja. I know she recently was appointed to your court, but I believe the information I got for her being appointed to your court or signed, was back in April. So I don't know with her being in court today, if she's going to have time to respond to the jury instructions that I sent over. So I'm asking you, how would you like us to handle that? Would you like me just to file my instructions and then in the meantime, we can sort that out, or how would you like that to be handled?
Just follow it. Follow your instructions. And Ms. Kamaja, you look over them. I'll let you submit whatever you need to submit if you have something you want to add or something you don't agree with. Okay.
And then we'll discuss it in the meantime together.
Okay. All right. So we'll continue.
And I'll keep the court informed as well as Ms. Bettiger regarding my contact with the witness in this case.
Okay. So we'll continue to jury trial on 5/14/25. Now I'll say update on complaining witness ordered for May 13th. All right. So we're all set. Bob will continue.
Thank you, Your Honor.
Mr. Kroski,
Thank you, Judge.
I'll see you in court, Mr. Kroski.
All right.
14th, okay?
All right.
All right, yep.
Thank you.
You're all set. Thank you.
Yep, that's perfect.
Okay.
And maybe next time when you go to court, wear clothes before the judge tells you to go put a shirt on. Just a thought.
All right, the court is on the record and calls the matter of people of the state of Michigan versus Charles Robert Zuba. This is file 23-6610 FH.
For the record, Your Honor, Michael on behalf of the people.
Here, on behalf of Mr. Zuba.
Thank you. So counsel, lots to go through today. As each of you know, the starting point of our discussion is that each of you is appearing via Zoom. That's obviously not in line with the court's general practice for sentencing hearings, of which this is, but it's because the attorneys made me aware of some certain information that affected whether or not we can proceed today in person to begin with. That information that I was provided started with at some point, I don't know whether it was yesterday or a couple of days ago, information was provided to my staff from either the prosecutor's office or defense counsel or both, suggesting that Mr. Zuba was lodged in Alpena County and was not, at least at that time, had not posted bond. There was arrangements apparently made for him to be able to appear via Zoom. I had instructed my staff to at least have the attorneys and Mr. Zuba available to that extent to make a record. Although, as the attorneys again know, generally speaking, I don't have sentencing hearing on felony matters via Zoom. But I at least wanted to allow the attorneys the opportunity to address the court in Mr. Zuba's presence. However, since I got that information and had my staff make arrangements and let the attorneys know they could appear via Zoom, the clerk's office and my staff gave me additional information. Again, I'm confident it came from either Mr. Rolla or Mr. Brown or both. But that information was that now Mr. Zuba has posted bond from Alpena County. And the next information that was provided was some sort of suggestion that Mr. Zuba may be in the hospital. I bring all that information to the attorney's information, and I want to make sure it covers this other information. We are here today for a sentencing, of course, because last month when we had a sentencing scheduled with a prison recommendation for Mr. Zuba, who's facing sentencing on his 7th and 8th felonies, he failed to appear. He failed to appear, though, despite 3 different circumstances that he brought to the court's attention through his attorney or otherwise. One of those claims is that he was tested positive for COVID. One of the claims was that he had a flat tire and he called the clerk's office to report damage. He also called either the clerk's office or my staff and reported damage to his home. Of course, last month was right after the horrific damage that was done from the Otsego County ice storm. And so I was willing, because of that and a claim of COVID diagnosis, to not only adjourn somewhat over to the prosecutor's objection, the prosecutor did object, but also required Mr. Zuba to show proof of damage to his home, damage to the car tire, and a positive COVID diagnosis.
Wow, this guy has the worst luck.
Because all of those things were claimed to the court, to various court staff, or to my staff at various points. So we're here again. Mr. Zuba now, based on the information I have, has been released from Alpena. He's no longer there. And therefore, it would be my estimation that he needs to be here today for his sentencing hearing. Mr. Zuba is not out in the hallway, is he, sir? No, you're right. I did not expect that he would be, but I wanted to also make a formal record of that. Mr. Rolla, given all of that background, first, does the court have the background accurate as far as you know?
It does, Judge, but I have some additional information I can provide to the court with the court's permission.
Go ahead.
In addition to the information the court provided, I would advise as follows, that late yesterday afternoon, our office received a call from Ned, who's the probation officer with the Alpena District Court, to advise that Mr. Zuba was at the time had been on probation and was again arrested, his words, just picked up for controlled substance, possession of cocaine, less than 25 grams, for which he was charged and sitting in the Alpena County Jail. He advised yesterday afternoon via his message that because of that, Mr. Zuba, quote, might not be available for sentencing in Otsego County tomorrow morning. After receiving that information, our office immediately took action to try and have a writ prepared so that way we could have Mr. Zuba available for this court. That writ was prepared, was sent to Alpena County, and Chester at the Alpena County Jail confirmed that they received the writ. They have acknowledged that Mr. Zuba would be available for Zoom today. However, they also indicated that after being arraigned yesterday sometime, the court set a bond which Mr. Zuba might be able to post. We later received information that that had been done. And again, it's my understanding Mr. Zuba is out on bond in Alpena County, but clearly was well aware of his requirements to appear before this court today, either in Zoom if he was still incarcerated in Alpena County, for which arrangements had been made, and if he had posted bond to appear in person. Thank you, Judge.
Mr. Brown, thank you. Mr. Brown, do you believe the court has had the background information correctly stated on the record today?
Ms. Deml, I couldn't hear you. Can you hear us?
This might not be interesting at all.
No, hear me?
All right. Can kind of hear you.
Hello.
There we go. All right. We're in the District Court of Ellis County, Kansas. This is case number 2025 DM 41, Matthew Deml, in the matter of the marriage of Matthew Deml and Camilla Jane Deml. Sir, are you Matthew Deml?
Yes, Your Honor.
And ma'am, are you Camilla Jane Deml?
Yes.
We're on for a final divorce hearing this morning. I've got a few questions before we start. The file does not indicate that Ms. Deml, you've been served with the petition in this matter. Have you been served with the petition?
Yes, sir.
You have. Okay, and how did you receive that petition?
Via one moment. Via DHL.
Okay. And Mr. Deml, did you send the petition by DHL?
Yes, Your Honor.
And did you have, did you get a receipt back showing when?
I
the
did
date
not.
that it-
DHL does not do that. I also sent a copy through the USPS. The only place I could find that does a signed return receipt. And as of right now, it's lost someplace in the Philippines.
Okay. Well, service of process of the petition is requirement. Ms. Deml, there's no proof of service of the petition in this matter. Are you wanting to proceed today and waive any proof of service of the petition to you?
Would it be okay if we wait for the USPS for me to receive the file that was sent?
What was that again? I didn't catch all of that. I'm sorry.
Is it okay if we wait until there's proof once I receive the file from the USPS?
Yes. So if you're not willing to waive service, the court has no jurisdiction then to grant a final divorce in this matter. And so until the court sees that there's proof of service or a waiver of service, I don't have any jurisdiction to proceed.
Camilla,
I know.
Just
Hold
get
on.
this over with. Sorry.
And I can, and I know, and that's some of the hurdles of pro se litigants is I know they just want to get things over with, but there is a process, there's requirements, and I can't just skip those requirements. I've got the final divorce decree. It indicates that there is an agreement that the parties have entered into an agreement, and I did not see that it was attached. Have the parties entered into an agreement?
I mean, as far as I would like to keep all my stuff that I have here in America and all my debts.
Okay,
I
Mr.
would like her.
Deml, I wasn't asking for
No,
specifics.
sorry.
If the parties had reached an agreement, because the decree indicated that there was a written agreement between the parties. Is that the case? Or is that a mistake?
I don't remember writing any type of written agreement.
Okay. Okay. Well, at this time, until there is proof of service, I cannot proceed. So either, and I cannot give legal advice either from the bench. Both of you are able, have a right to be represented by an attorney. If you want to contact an attorney's office and retain an attorney, you're certainly more than welcome to do that. But right now, as it stands, I don't have proof of service. So therefore, I don't have any jurisdiction to grant anything today. Mr. Deml, if you get proof of service, either through DHL or through the USPS, showing that a time and date of where Ms. Deml was served, and you fill out the return of service and file it with the court, then we can proceed. That, or if Ms. Deml changes her mind and waives service, then we can proceed at that point too. But at this time, we cannot proceed. So, one of two things. The court can wait till we have the proof of service and then schedule a hearing after that, Or we can schedule a hearing now, and come back at a later date to see if we have, a proof of service. Mr. Deml, I'll start with you. How do you wish to proceed?
I'd like to schedule something now. I was wondering if I could talk to Camilla real fast, just to ask her why she wants to wait for proof of service. Because
Hold on. Well, we'll take one thing at a time. So, Mr. Deml, you would like to schedule another final hearing?
yeah, she
Is that
said
correct?
she was going to get it today, but I guess she didn't. It didn't come.
And Ms. Deml, are you in agreement that you'd want to set this for another final hearing? Or do you want to wait until the proof of service is filed?
Hello, sir. I think you've mentioned earlier that the main requirements for it was like the proof of service, right?
Right, and so I'm just asking if you want to schedule another final hearing, or if you want to wait till the proof of service is filed to schedule that hearing at that time.
Maybe we can just like set another hearing. Would that be okay? Since we're
Yeah.
not sure if when am I going to receive the proof of service, so that might take.
And that's fine. And that's fine. We can set another hearing. Now, if this is going to be contested, if there is a disagreement regarding how assets and debts are split, you need to know a couple things. One, this hearing is broadcast on YouTube, so details about your assets and debts will be broadcast over YouTube as a public hearing. So when it's on Zoom, we have to make it public. So just so that you're aware that gets broadcast on YouTube. It is taken down at the end of the day, but the parties need to be aware of that. Also, if it's going to be contested, here's the requirement the court has. Then the list of assets. I need a list of assets from each party and a list of debts from each party, what their values are or how much is owed, and then the proposed division. So that'll be required to be sent to me before we have a final hearing if it is going to be contested. Do both parties understand that requirement?
Yes, Your
Yes.
Honor.
Okay. So we will schedule this for another final hearing. Ms. Deml, you heard Mr. Deml ask if we can put you in they call it a breakout room to talk. Are you wanting to talk to Mr. Deml after we're concluded here?
Yes, Your Honor.
Okay. So let's check if come on.
Sorry.
I guess if we can look 30 or so days down the road.
Honestly, what I've got right now in June is the morning of June 13th. That's really about all I have at this point.
What time would that be?
I can do our time anywhere from 10 to noon. I'll do.
Mr. Deml, I'll start with you. What is your preference in that time frame, 10 to noon? Hold this.
I mean, that'd probably be fine.
What time though?
10 would be the best for me.
Ms. Deml, does 10 o'clock in the morning on the 13th work for you?
Yes.
That'll be 11 o'clock at night for you.
Okay.
Okay. So we'll reschedule this for June 13th at 10 a.m.
Okay.
And if it is going to be contested, the requirement is for the list of assets, debts, their values, and how you propose to divide them. If the parties come to an agreement, you can submit that to the court as well, an agreement on how to divide the property and debt. And so we can handle it that way as well. So at this time, the hearing will be adjourned and then we'll set up a breakout room for you two to discuss anything. Mr. Deml, anything further?
Is there any way we can schedule it to the end of May? I'm trying to buy a house and to get a grant. I have to be able to file or get the house June 1st. And if I don't get this done before then, I can't buy a house.
Man, well, my calendar is terrible. I'm out of the office and some training at the end of May.
Camilla, do you understand you don't need to have proof of the
All right, Mr. Deml, we're not going to do this right here. Ms. Shack, is there any?
Judge,
anything?
the only thing I have is, I talked to you yesterday about we rearranged May 21st, but that's only 2 weeks out. I don't know if they can get everything they need done in 2 weeks. But if they can, you've got May 21st in the morning available.
Okay. All right, Mr. Deml, I'm sure you're wanting to do the May 21st. Is that correct?
Yes, Your Honor.
Ms. Deml, May 21st, what time would that be?
I can do a 10 o'clock or there also.
Okay. Ms. Deml, would you be available to reconvene on May 21st?
Yes, Your Honor.
Okay. All right. We'll do May 21st at 10 a.m. So, again, if the parties come to an agreement on the property and debt division, you can put that to paper, sign it, and submit that to the court. If not, again, there must be proof of service or a waiver of service. And if there is disputed, then the list of assets, debts, their value, and how they're to be distributed will be required at that time. That doesn't give you a lot of time, but we can certainly try on the 21st of May. Okay. Anything further then from either party, we'll set up a breakout room for you two to discuss things. But as far as on the record, anything further, Mr. Deml?
No, Your Honor.
Ms. Deml, anything further?
Nothing, Your Honor.
Okay. So we'll be adjourned. I'll log off. Make sure you stay on. Ms. Scheck will assign you to a breakout room and you two can discuss how to proceed in this matter. Thank you all. We will be adjourned.
All right, Mr. Wilkins, we are in court. I do need you to take your hat off.
Yep, I will. Sorry, sir. Okay.
All right.
Yeah.
These are citations that were issued on April 2nd of this year on 102nd there in Otsego Township. It's 2 violations. One is for seatbelt and one is for no proof of insurance. Mr. Wilkins, you're here on these citations to do one of 3 things. First is you could admit responsibility to a citation, or 2, you could admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or 3, you wish to contest the citation. In other words, to fight a ticket at what we call informal hearing. What were you looking to do?
The officer told me that if because I just bought the vehicle and I was driving it, he told me that if I showed the proof of insurance, that he would waive that.
Okay. Yeah, waivable usually means you come into court and you should show that insurance at the window because you didn't send it in, so I'm not looking at it. So
Okay,
you can tell me you have insurance all day. That really doesn't do us much good. Yeah, over Zoom doesn't really work. So here's what we're going to do. I'm going to give you an opportunity to send it, take a picture of it, text it to court. But let me ask you this. What are we doing on the seatbelt ticket?
Okay, now the seatbelt ticket, I was taking when he came up there, because I got pulled over earlier that day also for driving. It didn't have a plate on it because I just bought the vehicle and I had to drive it to work. Well, when he was coming up, I took my seatbelt off to get my title and to get because I already knew he was pulling me over when he turned around. So I was already, I pulled over.
So Mr. Wilkins, let's answer carefully here. Everybody takes their seatbelt off after, well, lots of people take their seatbelt off after they get pulled over because they got to go in the glove box. They know they're going to get all that stuff. That's not why you get this ticket. You get this ticket because before that, you probably weren't wearing a seatbelt. So are you saying you were wearing your seatbelt and you shouldn't have got this ticket? You want to fight the ticket?
Yes, sir. I want to fight the
All
ticket.
right. Then what we're going to do is have an informal hearing. So first thing I'm going to do is swear you both in. Go ahead and raise your right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do. Yes, sir.
All right. Mr. Wilkins, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right?
All right.
All right. And with that, deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation?
Yes, on April 2nd, I observed a white Tahoe / Suburban driving on 102nd. He went straight through 16th Street. And I pulled the vehicle over since I saw the driver of the vehicle wearing an orange shirt. And when he passed me going westbound, I did not see a seatbelt on him. So I then conducted a traffic stop on this vehicle, and I also observed that there was no plate on the vehicle as well. I made contact with the male driver of the vehicle, Joe Wilkins here, who I see in the courtroom today. Upon contact with Joe, he stated that he just got pulled over earlier in the day for the same thing for his no plate on his vehicle. He stated that he just bought the vehicle. I then asked for a title for the vehicle. He then provided me a title for the vehicle, and I observed that there was no date or any time, the proof of sale. I gave him a verbal warning on that since he got pulled over the day prior. I did advise Joe that that is not the reason I pulled him over. The main reason I advised him that the main reason was for his seatbelt. And he said, sorry, didn't have it on. I then issued him a citation for no seatbelt and no proof of insurance and gave him a verbal warning for the no plate on the vehicle.
All right, Mr. Wilkins, what is it you'd like to tell me?
Basically, he's pretty much correct on everything when he pulled me over. Actually, I was pulled over before he even turned his lights on. I knew he was pulling me over because, like I said, I got pulled over earlier that day for the same thing. So, when he came up there, I was all ready for him, handed him everything, and explained to him, hey, I just bought the vehicle. I already got pulled over one time today. And, you know, that I was getting insurance on it and getting it legal. I already had a date set up with the Secretary of State. And I was going to get everything taken care of on it. The reason I didn't pay for insurance ahead of time before that is because I had to wait to get paid. They wanted so much money for it, and I had to wait to get paid to, you know, pay for it.
All right, is that all you want to tell me?
Yes.
All right, so here's what's going on, right? You just bought the car. There's a grace period. If you know, first of all, the easiest way to prove that that's true is the proper sale of the vehicle. In other words, right on the title, it should have the person that sold it to you signing it and saying, here's the date and here's what we bought it for. You didn't do that, right?
Yes, I didn't.
Okay.
Yeah.
Had that been on the title, I bet you they probably would have even said, well, you know, go get that plate, go get that insurance, because they would have had the proof right there in front of them that this is new to you. Everybody would give you some time to get all that stuff in order. But now they got to say, okay, well, maybe you did just buy the car, but they can't tell you just bought the car. So they're going to say, okay, no insurance, you know, go get your insurance. It's waivable. I'm here ready to give you a break about insurance. If you got the insurance, we're just going to believe you on the title. But that's not really why we're having an informal hearing. We're having an informal hearing because you told me, oh, yeah, I was wearing my seatbelt, shouldn't have got the ticket. You just heard the deputy testify that not only did he pull you over because, you know, he could tell you weren't wearing a seatbelt because of the shirt you're wearing, but then when he told you that's why he pulled you over, that you said, oh, yeah, sorry. But then in your testimony, you didn't mention the seatbelt at all, either way, either to tell me, yeah, I wasn't wearing the seatbelt, or, oh, no, I was wearing that seatbelt. He must have been mistaken. So
Right.
I'm ready to give you this break on the insurance, but we have this question about the seatbelt. Are you
Seatbelt.
telling me, yeah, you should have got hit for the seatbelt ticket? Or are you telling me that you just forgot to testify and really that the deputy's wrong and you were wearing your seatbelt?
No, the deputy's not wrong. No, deputy's
All right,
correct,
all right.
100%.
So that's kind of what I was kind of looking for is, you know, how much credibility you were going to have with the
Yeah,
seatbelt
I
argument about
understand.
whether or not we. All right. So here's
I
what we're going to
understand.
do. The seatbelt, that's a $65 ticket. You got to pay that. All right. Because I would find
Okay.
you responsible on that. Now the insurance, I need to see that you got the insurance, right?
Okay.
You can't just say you got the insurance. So what we're going to do is on the insurance ticket, I'm going to say, hey, you know, by 5 o'clock today, by end of business today, I need to see the proof that you have insurance on this vehicle. Now, when we're done here, you're going to call the clerks, right? 673-0400. It's right there on your notice to appear today. They're going to give you an email address. I'm pretty sure it's districtcourt@AlleganCounty.org, but I want you to talk to them. And then you just take a picture of your insurance and you text it to them or you send it as an email. And then as long as I see that before 5 today, we're going to give you a break on the insurance, all right? Because it's a new vehicle.
That.
You're telling me it's up to snuff. Did you get your plates?
Yes. Yes,
All right.
I got my plates. I got everything taken care of on it. Yes, sir.
All right. So you understand what the deal is. By 5 o'clock today, if I see that you have insurance now, then we're going to dismiss that ticket. If you don't do that, then you're just going to also have to pay the $145 on the insurance.
All right. Is there points on my license for a seatbelt?
No.
Okay. Okay.
Well, I guess I'd have to double check that, but I don't think that's considered a moving violation. I think it's just a fine.
Okay.
All right.
Okay, that's what I was concerned about mainly.
All right. So that's I'm going to write right on here on the ticket. That's your deal. Is by 5 o'clock today, you show us the proof that this car's up and running, up to snuff, and then you don't worry about the insurance ticket. You just got to pay the $65 on the seatbelt. All right.
I'll send it within 15 minutes.
All right. Thank you.
Thank you, sir. Thank you.
Oh, yeah. No, I always put mine on. I can't go anywhere without it, especially after the accident. Like, yeah. You have one life-changing event like that, and yeah, you find it a bit important. All right, guys, we're gonna save Judge Wade for another night. I am getting very sleepy, and if I try powering through an hour of Judge Wade, I'm gonna be sleeping on my desk. Nana Laura is gonna be calling me, waking me up. Yeah, she's been out for a bit. Oh. Yes. Good night, everyone. You go back and watch the Hooker Dick case. Yeah, it was, you know, an interesting one. I love you guys so much. I know he dropped that tooken. It tooken me everything not to pause it and point out the tooken that got dropped. All right, guys, and a big thank you to S. Buford for my shirt. I love it so much. It is so soft and comfy and lightweight. It is a perfect summer shirt. I love it, love it, love it. Thank you. Be safe, be well, sleep sweet, and much love.